U.S. draft merger guidelines. What is at stake? I think welcome everyone. I think the idea of this debate is to have Professor John Kwoka, a very known and distinguished professor of economics at Northeastern University, bringing his views to us on U.S. draft merger guidelines and guessing how this may influence the world and in particular Brazil. Also, we're going to have Jenn Mellott, very well-known Freshfields antitrust partner in DC and Brussels as well, commenting John's view. And I think she'll try to bring a more pragmatical view on the challenge perhaps that the new administration may face with regards to these guidelines. All of this, I think, in a moment in which we are discussing our vertical and conglomerate guidelines, which we just terminated the phase of consultation, and it's now we're waiting for the publication of the guidelines. It's also worth mentioning that IBRAC has prepared a very robust book consolidating several articles on the topic, which will be released in our event, our international event, in about 2 weeks here in São Paulo. So it's a pleasure to have you, Professor Kwoka, and also Jenn, for this debate. And congratulations for Bernardo that organized this and was able to bring this team for the debate. Bernardo.
Thanks much. I'll just highlight that we envisage here to have some warm-up of sorts towards our conference in a couple of weeks. And to have John here is a great honor. He's very well known, so I'll go straight to his talk. But just invite you also to, apart from antitrust revolution, I'll highlight a most recent piece of him that's precisely related to what we have here to discuss. It's a book that's Controlling Mergers and Market Power, a program for reviving antitrust in America. It's a piece that has many interesting features, separated by precise chapters. It's very instructive, I guess, and very lots of food for thought. So I'll invite all of you to get this through CPI. It's easy to download. It's not, you don't have to wait for mail. So it's a must-have, must-read. Also, thank you very much, Jenn, for having this discussion here. And Jenn will present also. He's in a position that would enlarge the focus, I would say, not just to US but also to Europe, as she's in practice also in Brussels, and has been working very hard on this two sides of the Atlantic, as we say. So let's start. We'll have a presentation from Professor John Kwoka. It's our great pleasure. Following comments from Jenn, I'll jump in to present some questions after this, and we'll be awaiting also for your contributions through our chat. We have 1 hour and just 2 panelists. The presentation for those show. So it's show time. John, please. Floor is yours. Jenn after that. Thank you so much.
Thank you, Bernardo, for organizing this event, and it's a great pleasure to share this with Bruno and Jenn, whose comments I look forward to. As Bruno said, I am on the economics faculty at Northeastern University in Boston. 2 years ago, Lena Khan, who had just been appointed as chair of the U.S. Federal Trade Commission, invited me to join the FTC on a temporary basis to assist with writing and drafting new guidelines. I spent a year and a half there. Hoped by the time that I left that the draft guidelines would be out, but they were not. I nonetheless left several months ago. So there have been some changes since I last saw them. I can't speak to all the details, but what I would like to do, and I think this is what Bernardo had asked, is to give an overview of the basis and motivation for the new guidelines, and then to explain how that, from that motivation, some of the specifics follow from that. So, I think the broad answer to the question of why new guidelines were written has 3 or 4 parts. One is that it was generally believed, not unanimously, but generally believed, that there was under-enforcement against mergers in the US for some period of time. The history is, I think, well known to most people, where the Chicago School advocated an efficiencies view of most mergers. And from that followed decades of enforcement, which was relatively tolerant of mergers and resulted in higher concentration and competitive harms. We can debate some of the research that I and others have done on that issue, but that was certainly one of the motivations. The second motivation for redrafting the guidelines is that the 2010 guidelines did not pay very much attention to certain issues that it was felt needed more specificity in the guidelines, more attention. Among them, I'll talk more about others, but among them was the issue and concern about the effect of mergers on worker wages and working conditions, and in our agricultural sector, in the prices that farmers and other sellers of goods to more concentrated buyers were receiving. The third area is the tech sector. Tech sector wasn't of the same significance 20 years ago when the last guidelines were drafted, 15 years ago rather, but now there really was a widespread view that the guidelines needed to address tech issues much more forthrightly. So it's not unusual that the guidelines are redrafted. They have been redrafted in the past every 12 to 15 or more years to varying degrees. And the 2010 guidelines, as I mentioned, it was felt, did not come to grips adequately with the issues facing the US economy. There are other specific, more process reasons. Those were substantive reasons, but there are some process reasons as well that the agencies, I think, believed needed to be re-examined. One of them was the focus in the 2010 guidelines and the earlier guidelines on market power and prices and consumer surplus. There was a view that I certainly shared that was a narrow way, a narrow lens through which to see competitive harms. And the new guidelines, as I'll describe, focus more on what's called lessening of competition and less on traditional consumer surplus issues. A second was that the focus on price gave an undue emphasis to price over some important non-price effects of mergers, quality issues, innovation issues, and the like. And again, the 2010 guidelines did not really address those except in the most passing way. And the third process issue had to do with the focus on market definition. In the US, because of our judicial system, merger analysis and cases that are brought by the agencies to the courts need to address market definition, but it's become such a threshold issue that in many cases never get past the market definition question to examining what is the competitive harm. So the new guidelines are an effort to focus attention on competitive harms, while of course having to address the market definition question in due course, but rather than make that the threshold question, because oftentimes one never gets past that, now the issue has been front and center about what is the theory of harm, what is the competitive harm, what is the nature of the concern. So these are the motivations for the new drafting of guidelines. And the guidelines were drafted by myself with other people from the Federal Trade Commission, together with another group of staff members from the Justice Department, working very much in concert. These were overseen by both Lena Khan, the chair of the FTC, and Jonathan Cantor, the Assistant Attorney General for Antitrust at the Justice Department. Throughout, they were informed and consulted about directions that they wanted the process to evolve in. So the nature of the concerns kind of drove a number of very specific things. And let me kind of explain some of the specifics now, touching down on some of the issues that have been seen, I'm sure you've seen in the draft guidelines. I might note, as you all know, that the guidelines are still in draft form. There was a comment period of 60 days, which is now expired, but the draft was put out for comment. Several thousand comments were received from both the antitrust community, but also individuals who felt that they wanted the agencies to understand how they lived and breathed in an environment where mergers made a difference. All of these comments, together with an earlier round of comments at a very early stage, are read by someone, and some of them, some of the comments are directly on point to the language and focus of the guidelines themselves, and others are part of the record explaining what it is that people are looking for from the agencies. Lena Khan and Jonathan Cantor have made a very specific effort to explain that the guidelines are something that should matter, that people should understand matters to them in their lives. People who have experienced hospital mergers and in the agricultural sector, and consumers more generally, have reactions to what they see as mergers occurred, as stores close, as hospitals consolidate, et cetera, et cetera. So all of that is part of what the agencies have been determined to do, is to make sure that this is not just a document in a small corner of the policymaking world, but really something that more broadly affects people. And the agencies have sought to offer people a way of explaining how the merger process affects them. So again, as I said, let me explain several ways in which those themes about the failures and omissions and lack of specificity in the earlier guidelines, how this has changed in the new guidelines. So as I mentioned, there's a reordering of things in the guidelines so that there's much greater attention up front to theories of harm. Guidelines now have basically 12 different, literally guidelines, but sort of scenarios by which a merger may adversely affect market competition and consumers and other outcomes of interest. And they are an effort to broaden the lens so that it's not simply a matter of looking for, as the old guidelines did, directed attention to coordinated effects and unilateral effects, so-called, that really dominated the discussion in the preceding guidelines. So this is more broadly and more expansive in terms of the issues. So there is concern with, as I mentioned before, with worker wages and monopsony power, buyer power more generally. There's much greater, a guideline that talks about potential competition questions. Potential competition had a passing reference in the preceding document and now has its own place as one of the guidelines. There's discussion of innovation in several places throughout the document that's more expansive than before. There's a recognition, of course, that much of what we tend in the past to have been concerned about has to do with short-term price effects from mergers. Whereas in many sectors, certainly the tech sector, but others as well, at least as important as short-term price effects are the longer-term effects of mergers on innovation, on technological change, on firms' incentives and resources for progress on new products and new industrial processes. The tech sector being Exhibit A, but many other sectors as well. There's also attention to what are called serial acquisitions, that is, roll-ups, so-called in the US language, but industries where a whole series of smaller mergers, sometimes not reportable, but a whole series of them end up consolidating a sector over time. There's now discussion about how that's to be handled in the guidelines, because that has been a practice in certain sectors, veterinary clinics and dialysis centers and some other areas of the US economy. There's also discussion of trends in concentration and how that's to be treated, because there is language in the law that says industries that are undergoing substantial trends in concentration need to be examined more carefully. And in addition, there also is discussion now about entrenchment, which I think is an important addition to the standard list of concerns. There's concern about mergers, which may not affect price right now, but insulate companies or a market from competition from new entrants or smaller competitors, so-called entrenchment. So these are areas that previously had received little attention, sometimes no attention, sometimes passing mention in the 2010 guidelines. But with examination of markets, these are now viewed as of greater importance. I also mentioned that there's a refocus from consumer surplus and market power to lessening of competition. Of the basically 12 or 13 scenarios, guidelines they're called, at the beginning of the new document, I believe 8 of them talk about lessening of competition as the concern, and the term market power does not appear there. And it's an effort to focus attention on the fact that in some markets, the term, or for some mergers, I should say, looking at consumer surplus and market power is not helpful. For example, I mentioned innovation. It's literally impossible, though the agencies sometimes try this, to predict what the outcome of an innovation process would be with enough specificity to be able then to predict what the effect of a merger would be on the price of a product that doesn't yet exist. And so looking for consumer surplus and price distortions of a traditional sort is really to ask for the unattainable, where the concern has to do with innovation or with potential competition. Looking for price effects is also not particularly helpful in cases where of zero price markets, obviously, or two-sided markets where the prices don't behave in the usual way. So there, the term lessening of competition directs attention to the way that a merger may affect the process of competition now with predictable effects in the future, rather than insisting that we try to understand the effects 2, 5, and 10 years out, where arguably the companies themselves may not fully understand it. So the guidelines also strengthen the standards, return to standards before 2010 for the share and concentration thresholds for standard horizontal mergers. Guidelines for many iterations up until 2010 had HHI thresholds, which had served reasonably well. They were changed in the 2010 guidelines. They were relaxed, allowing for this, more mergers to be approved. And that was judged to be part of the problem with under enforcement of mergers. And so it was simply a reversion to the preceding levels which had been in place for quite some time. We can talk more about that, but that was one of the architects of the 2010 change, in fact, recanted and has advocated going back to the preceding ones, just as one small fact. It's also true, as I said, that there's now attention to new issues, vertical mergers, for example, now, and mergers between so-called related products and services are now explicitly in these guidelines. These are no longer the horizontal merger guidelines. They are the merger guidelines, period. The view that underlay this was a view that vertical mergers raised the same kind of competitive concerns as do other mergers. The vertical mergers are simply one mechanism for exercising market power, for realizing or achieving greater profit and price elevation in a particular market. Classically, of course, a vertical merger that puts an independent producer at one stage at the mercy of the vertically integrated firm. The effect of that vertical merger will be to diminish competition faced by the integrated firm, and as a result, allow it to raise price or to exercise in other ways its market power. But the vertical merger is simply a mechanism for achieving what the integrated firm is seeking in any case. So in the past, as of course you know, in the US history of guidelines, there was an effort to write vertical merger guidelines. Those have not been enforced for some time because they were viewed as out of date and largely mistaken. There was a brief effort a few years ago, but that was retracted, a brief effort to introduce new guidelines. The present draft guidelines now has a section on vertical mergers and related market mergers. That is an effort to set out the factors and considerations that will drive an analysis of these sorts of mergers. Again, recognizing that much like other strategies that a merged company might use, vertical mergers is simply one mechanism for extracting for exercising greater market power in the first place. So we can talk more about that as well. I understand that different jurisdictions are viewing vertical mergers differently. The CMA in the UK, or recently, I guess 3 years ago now, issued new merger guidelines. They have essentially a section on vertical mergers within them, and the US draft more fully integrates the notion of verticality as one dimension or one concern about mergers overall. Let me conclude by noting that the draft guidelines do a few other things as well. They have language that are an effort to make more precise and maybe more stringent the so-called rebuttal arguments that companies can make, defenses to mergers based on efficiencies or entry conditions. What is not in what's also true, I should say, that many people have commented on, is that the guidelines rely heavily on legal precedent. They do so because, unlike many jurisdictions, the US system is heavily reliant on the court system rather than an administrative process where mergers are reviewed by an expert agency. Our mergers go almost immediately to court, where the agencies have to explain to a non-expert judge, a single judge, mind you, who is randomly drawn from a panel, and they have various prior views about mergers and competition policy, but it goes before such a judge who renders an opinion that oftentimes is difficult to overturn. So the guidelines need to be written in a way that's accessible. This is the argument made by the agencies. It needs to be written in a way that is accessible to the courts that are the ultimate arbiter in the US process. It's for that reason that so much of what you read in the draft guidelines is footnoted to legal precedents rather than anything else. What I think is not much in evidence is the concern about the so-called neo-Brandeisian, the non-economic objectives of antitrust. Lina Khan, of course, made her reputation by embracing a number of arguments about the dangers of mergers and high concentration to political and social values. And whatever one may think of that, I think one would be hard pressed to find any evidence of that in these merger guidelines. These are, I would say, largely an effort to strengthen, toughen, if you will, the standard process, but it is readily understood, I think, by people, to be really an extension of a fairly traditional line of thinking about the way that the agency should analyze and review mergers. We will know, of course, whether that works once we first off see the final version, which will probably be early next calendar year. And then at the end of the day, it will be tested in court as the agencies and their staffs try to use the guidelines and explain to the courts how the agencies now are thinking about mergers and to urge the courts to do the same. That let me conclude there and look forward to Jen's comments and to any questions that people may have. Thank you.
Perfect. Thanks very much, John. And maybe let me just jump in with some reactions to that. And I should say for the audience that in the spirit of true debate, we did not exchange any views on this in advance. So these are my off-the-cuff reactions to what John has said. I think when we think about the merger guidelines, when I think about the merger guidelines as a practitioner, it's important to think of those in the mindset of what are the merger guidelines for? What do they do? There have been merger guidelines since 1968. As John said, they've been revised every sort of 10 to 12 years since then. But ultimately, these are the views of the agencies, written down by the agencies, of how they think merger enforcement should work. But ultimately, in the United States, we have a system where the agencies have to bring a merger to court in order to prohibit it, to block it. And so the guidelines don't have any legally binding effect. They are simply the agencies espousing how they think merger review should work. And at the end of the day, courts take them as persuasive. They take them as a factor to be considered in how they analyze mergers, but they also look very carefully at precedent in the courts that have that also guide how they look at mergers that come before them. And what is interesting about the merger guidelines is, when they came out, I think the point of view of the legal bar was that there was really not that much that's surprising in the guidelines, because they say all of the things that we've been hearing from Lina Khan and Jonathan Kanter for several years now about their enforcement priorities and how they think about antitrust law. But you have to keep in mind that this is a philosophy that so far has failed to produce results in court. The agencies have a losing track record in court under Chair Khan and under Assistant Attorney General Kanter. They have suffered losses across basically all of the theories that John described. They've lost vertical deals like United Healthcare and Change, Microsoft Activision. They've lost potential competition deals like Meta Within. And they've also even lost horizontal enforcement actions that involve very narrow market definitions. So when you think about this, we're going to go away from the SNP test and thinking about market definition up front and make that sort of part and parcel of the whole, where the agencies have tried to focus on the competitive effects and zoom in on these very narrow market definitions, like in US Sugar, Imperial Sugar, Booz Allen Everwatch. They have lost those cases too. So just because the agencies have put out new merger guidelines that say all kinds of things does not necessarily mean at the end of the day that the outcome in merger cases in the United States is going to be different, because the courts have the final say. And so far, the courts have not been particularly accepting of these theories. The other point I would make on the persuasiveness of the guidelines to courts is that one thing that I think will remain to be seen in how courts look at and value these guidelines is that when you look at some of the recent historic sets of guidelines, those have been bipartisan. So the 2010 guidelines were approved 5-0 by a bipartisan FTC commission made up of Democrats and Republicans. Here we have draft guidelines that have been put forward by an FTC that has no Republicans currently sitting on it, so it's entirely Democratic, and a DOJ with a democratically appointed assistant attorney general. And so, there is potentially scope when courts look at these guidelines to say these are more partisan than guidelines we've seen in the past, and therefore we don't take them as persuasive as guidelines we've seen in the past. Another, reaction to how we think about these guidelines, I think, John described these guidelines as modern, as a way to modernize antitrust enforcement. Even though the guidelines say, I think in 3 or 4 different places, that they're designed to address issues in the modern economy, when you read them, they're not necessarily all that modern. In many ways, they are a return to pre-1982 merger guidelines. We return in kind of the structural presumptions and market shares, HHIs, all of those levels return to pre-1982 levels. There's lots in the guidelines about vertical cases. Vertical theories of harm are not new theories of harm. The AT&T Time Warner enforcement action was the first vertical case since 1977 that the agencies brought. Same thing with these sort of conglomerate portfolio effects where you look outside of the horizontal overlaps at the broader portfolios of the parties. The recent Amgen Horizon enforcement action that was brought was the first case since 1980 based on a conglomerate effects theory. So some of these theories are not new. They're dredging up a very historic way of thinking about antitrust enforcement. And, tied to that, when you look at the guidelines, it's true, they cite to case law. The guidelines have their basis in precedent, but almost all of the cases cited in the guideline are from before 1980, the 1980s. And so this entire sort of modern history of antitrust enforcement in the courts just drops out of the guidelines as if it never happened. And when you think about how a court will look at the guidelines and look at case law when they look at an enforcement action, I think it's clear that they will look at both and are continuing to look at both. And so the agencies have to contend with 40 years of modern enforcement precedent in court. We can't just write new guidelines and then say, oh, that never happened. We don't have to work with all of that. I think just 2 other more practical points that I wanted to raise, which, don't necessarily lend themselves to the theoretical discussion of whether a merger is anti-competitive or not, but are very much front of mind for companies that find themselves in the midst of this process. One is that the merger guidelines don't address how the agencies view remedies, which is normal. The merger guidelines have never addressed remedies. There are separate remedies guidelines that deal with that. But as a practical matter, both Chair Khan and Jonathan Cantor have had a philosophy as they have been leading these agencies that is very anti-remedy. They take a view that there's been under-enforcement in the past, that remedies that have been agreed by the agencies in the past have been ineffective, and therefore they would in most cases rather bring an enforcement action in court than agree a remedy with the parties. And when you pair this more aggressive enforcement agenda, more radical theories of harms, return to lower structural presumptions, with the fact that remedies have all of a sudden become persona non grata in the US, that means that transactions are simply, certain transactions just become impossible to do. And you can kind of think about that as you want, but that is the effective result unless parties take a transaction to court, which more and more parties are willing to do. And as I mentioned previously, the courts really have been kind of holding up against this enforcement agenda, and the agencies have a losing track record. The other point that is really a practicality is that it's important to think about what is happening with the merger guidelines in part and parcel with what is happening with the HSR form in the US. So around the same time that the agencies announced the revised merger guidelines, they also announced that they're considering massively restructuring how the HSR notification process works. It used to be, or it currently is, that the HSR form is sort of a 10-page hyper-technical document. You can put it together in 24 hours if you have to, which I've done. Usually it takes about a week, and it doesn't cost very much. You put it in, and then the agencies have lots of powers to request all kinds of information and documents and things and deals they want to look into. But for the overwhelming majority of notifiable transactions, that's a very simple process. Now, alongside these new guidelines, the agencies are saying, also, we have a whole lot of issues we need to look at, and we don't get enough information in the form to assess all of these things: labor markets, portfolio effects, vertical effects, merger or horizontal effects. And so they now want a more kind of EU style or even Brazilian style filing that is 200 pages long, has written narratives describing everything and anything. And you have to keep in mind that the overwhelming majority of transactions don't raise competition concerns. They don't need to go to an extended review. They still get cleared in the first 30 days. Most of them don't even get a question. When we talk about the transactions that are potentially problematic, it's a very tiny slice of deals. And what this new HSR form does is it imposes a massive process burden on companies to these transactions that don't raise any harm, based on the presumption that we need more information under the new guidelines and under the new enforcement agenda to look at a much broader scope of potential issues. There are other ways that could be done than kind of quintupling the cost of putting an HSR filing together. And I think, I raise this only because I think for most companies that are doing deals in the US that have to be reported, I think people are interested in the new merger guidelines. They see that they just are a kind of written down version of what the agencies have been doing for the last few years anyway. But when I talk to clients, it is the HSR form that gives them heartburn. It is the idea that they're going to have to spend $300,000, $400,000, $500,000 to put together just a basic filing form for a deal that nobody wants to look at. So as a practical matter, that's really important to companies, even though in terms of the kind of thinking around how we analyze deals, it's obviously not relevant. So that is just my kind of immediate reactions to some of these points. Very happy to cede the floor back.
Great, Jenn. Thanks much. I guess we would like to hear some reactions also from John, and then we can continue with some. I have 2 points to raise of my own, but I'll do this after John's comments.
Thank you, Jenn. I'm tempted to say I agree with about 90% of what you said, but I'll let you guess what the 10% that I disagree with is, because therein lies sort of the interesting discussion, which we ought to continue afterwards. I've noted down, I think, what your 4 or 5 major points were. Let me briefly respond. One, as you said, you pointed out that the FTC and the DOJ to some degree have a fairly dismal record in court so far. Not so much based on these guidelines, but based on the notion of a more expansive view of what types of cases ought to be brought. No one prefers to lose, but it's to some degree maybe not surprising that some early initiatives have lost in court. 20 years ago, the Federal Trade Commission lost a string of hospital merger cases and famously stopped bringing those cases while it assessed why it was that it was losing those cases, and used them as a learning opportunity to restructure type of proceedings that they did. And then, as you, of course, the FTC has had a much greater success rate in hospital mergers since. So it's not that anyone prefers to lose, but so long as the losses are for reasons that can be assessed and then can be remedied, it will help the agencies bring cases better structured better focused to deal with the criteria that the judges will use. On the other hand, let me just say that from my own perspective, some of these cases passed before me, so I cannot really comment on the specifics. But bringing potential competition cases is a difficult matter, but I personally think it's really one that has great value and needs to be explored. So losing some of them, again, if they're used as opportunities to learn more about how to fashion a winnable case, I think is still a worthwhile endeavor. If the agencies continue to lose case after case without, any successes, then I think then there's a broader issue. You also mentioned the sort of partisan nature. Let me just concede that that's an issue, but by the time the final guidelines go before the FTC, I think that the 2 Republican seats will be filled. And so far, it has mostly gone with 3 Democrats, not entirely to begin with. The beginning of the process had 1 Republican. Then there's this period of time with only 3 Democrats. But by the time the final guidelines are reviewed by the agency, it will once again be a balanced group of 5 commissioners, which is not to say that there will be agreement on them, but it will get different scrutiny for sure. You point out that the guidelines in some ways look like a throwback with citations to 40-year-old cases. Let me just say that if it were true that this was a legal brief only and not reflecting modern economics, I would be deeply concerned about it too. I am an economist after all, and I worked on the guidelines with a view to bringing modern economics into it. My view from many discussions with Lena Khan and others is that Chair Khan and Jonathan Cantor too want to fully utilize the law as it has been written down and as it has been reviewed by the courts, and also to fully utilize economics as well. So the foundation in the guidelines sets out the legal precedents that will guide the cases that are brought. But at the end of the day, the arguments that are going to be made in court, that have been made in court in cases, continue to be economic arguments. And I don't think that that is going to change. I think the idea behind the legal citation is to guide the judiciary to the fundamental precedents that should govern their way of thinking about it, but then to take the economics from that, use that as a foundation for the economics. If anything other than that happens, I will be the first to declare my disappointment. But it does read, I'll grant you, I will concede the fact that it does read as a somewhat different document than what I've just described. Remedies. I've been a pretty well-known critic of remedies policy, so you probably aren't going to be surprised that I think that revision of remedies policy was in order. The guidelines, as you rightly say, never have had spoken about remedies, but the remedies policy dovetails with what the guidelines do. And from a company perspective, I think it's fair to say that the parties you counsel do want to know more about how the remedies policy will work. I think some of that is clear as a result of what Lena Khan and Jonathan Cantor have done in the past year or two with regard to opportunities for remedies. By and large, these have not been met with much agreement by the agencies. The HSR form, without making a broad case for it, let me just point out that the thinking behind it was that for many mergers, this should, in fact, speed up the process because the agencies automatically want some of this information within the 30-day period. And so the fact that the agency knows that it wants this, if the parties give it to the agency up front, then it will, in some ways, short circuit one of the inevitable steps. That said, if it imposes a large burden on a good fraction of cases that raise no competitive concern, then I do hear you loud and clear. But thank you for all your comments. Like I say, I agree with most of them and certainly understand your perspective. And I thank you for so quickly grasping what it is that I was trying to convey and for making some good constructive responses.
Let me just add, thank you, John. I guess Jenn is eager to bring some more comments, but I'd like to add a comment on a specific point that John brought about the role of economists before hearing Jenn about it. Thing is, somehow economic evidence has been seen by and large as hard evidence, and somehow this is akin to see our role as mostly related to pricing and modeling pricing, UPPs and the like somehow. But somehow I would say that to enlarge the scope of analysis beyond price is it's not to diminish the role of the economist, but somehow it will be, as I said, and I guess John is putting some views akin to that, it will be kind of bringing more fun to us, not just to focus on prices and models, but to put on a larger view on the industry that is related to the merger. So the role of the economist is somehow, I guess, paradoxical. Somehow is when people say that they will enlarge their focus, will say we're not here to the economics of pricing. But on the other hand, as every economist would say, on the other hand, of course, so on the other hand, we would see a more really a playground for us, so to say, and we'll be able to focus also on structure, on technology, innovation, and many other features of the industries. So that's just one comment. Yeah.
Well, let me just add one small comment, and that is that I think one of the concerns, a theory, is that economists, we economists, like our models are strongest when we talk about pricing issues and quantity issues, and that has driven, arguably incorrectly, the focus of the merger enforcement process to spend much too much time thinking about the things that we do well, we economists do well, and not enough time thinking broadly about the way that competition may be lessened in dimensions other than, price and quantity. And so I think, economists, I criticize my own profession here. Economists are to some degree responsible for this misplaced focus. It's not that price is unimportant, but there are many other things that are important too. And every industry is different. The strategic variable in one industry is not the same as another industry. And trying to force fit everything into a consumer surplus market power price analysis runs the risk of distorting what's actually going on. Now, that said, the pricing focus and the models are powerful tools. And one of the reasons we use them is that they have a sense of objectivity and precision that is useful, can be conveyed oftentimes successfully to a judge, whereas a broad, expansive description of competition in the industry without bounds, without criteria, without metrics, runs the risk of saying that everything matters, and but we can't really explain exactly how and why. And so that is the danger of too broad a focus. The guidelines, successfully or not, I think try to bridge that gap by saying that other things do matter. Here are the tests, here are the criteria, here's the method of analysis that the agency will use for thinking about potential competition or innovation or worker wages. And where useful, price analysis and the models will be used. I personally think that these are very useful in thinking about unilateral effect stories. They're much less useful for some other dimensions of competition. So the idea is to think about how competition works in an industry and how it might be distorted by a merger, and then to apply the relevant techniques, which give economists plenty of opportunity. And again, the danger is that it's too unbounded. We need to be sure that we don't say everything matters, and as a result, not be able to explain precisely how to think about the effect of a merger on competition in an industry.
Just to jump in and react on a couple of these points around sort of the role of economics and the economic thinking here. I mean, just as a practical matter, what I would say is you can certainly see both in the guidelines themselves, but also in just the day-to-day interactions with the agency, the prominence of the economists and the economic thinking that's happening in cases today. I think that's unquestionable. And, you know, when I think about when I first started practicing antitrust law, I think there was sort of an impression that every case had economists, the agencies have economists, the parties have economists, and you'd come up with a model, we'd come up with a model, and then they'd all kind of cancel each other out, and it didn't really matter. Now, I think we really do see the economists at the agencies taking a much more prominent role in investigations, you know, really driving the thinking around the theories of harm for a lot of these deals. So I think, you know, good for everyone on this call, lots of work for economists going forward, because I think that really is very front and center in how these issues are being analyzed right now. I do want to react to just a couple of John's points, and I think I've noted them all down. But on your point about the precedent in the guidelines, and you know that obviously we look to these older cases, they inform the economic theory going forward. I think that's fair. I mean, obviously those cases are still valid cases; they're on the books. It's not as if it's kind of somehow incorrect to point back to them. But I think, you know, the recent precedents are also still relevant. And the fact that the agencies have lost cases in court, I mean, you could say maybe it's time for a reset, they change tactics, and then they'll start winning going forward. But I think you also could look at some of the recent cases involving vertical issues or potential competition issues and say, each time that the agencies bring and lose one of those cases, it creates another recent precedent where the next case becomes even harder to bring. And so, you know, do we get to a point where if what is in these merger guidelines are really what the Biden administration's enforcement priorities should be, you know, I think you have to ask if we're getting to a point where what we really need is a new law, because we have this precedent on the books that, you know, is really pretty entrenched on some of these topics at this point. That's a whole nother question. That's been something that's been obviously tried quite a lot in recent years without a lot of success. But eventually, if what is really in these guidelines is where merger enforcement is going, it feels like something is going to have to change in the law itself to create room for that. Otherwise, the precedent, recent or old, is just going to create kind of a bottleneck there. I think that partisan point, you know, also raises the comment you made about how there will be 2 Republican commissioners by the time these guidelines are approved. I think that seems like it certainly will be the case. I think still remains to be seen whether they will vote in favor of the guidelines. So, but certainly your point's taken that if, you know, all 5 of the commissioners vote in favor of the guidelines, that, you know, partisan point would go away. I think the most interesting comment is on the remedies policy, and this idea that, you know, remedies had gone, you know, had become too permissive, they weren't working, and that we needed to kind of tamp down on cases where remedies are appropriate. You know, my own view is that even if you think that that is the case, and certainly lots of people do think that is the case, that where the agencies have swung currently is too far in the other direction. I mean, they really have taken a stance that remedies are never appropriate, full stop, unless we find ourselves in court in front of a judge where we know we're going to lose, and then we might be willing to kind of work something out. That's what happened in Assa Abloy. That's what looks like it happened in Amgen Horizon. And what's happening in the US with remedies that I find really fascinating is the agencies are sort of quietly encouraging what we would call a fix-it-first remedy in a deal, where the parties sort of quietly excise the part of the deal that raises an issue before they even file the HSR. So they present a clean deal to the agencies that they can't enforce. And historically, that would have been something the agencies would have hated, because it means they don't have any oversight over the remedy. They can't make sure it's sold to a decent buyer. They can't make sure that they're monitoring whether the ongoing, kind of transitional agreements and things work. And so when you move all the way to a world where you have such a rigid anti-remedy stance that you tell companies, but if you just like fix it quietly yourself before you look at it, that's okay. To me, that's way too far in the other direction. And there must be somewhere in there where there are cases where remedies still make sense, even if that Overton window has sort of shifted from where we were 5 years ago. And that's a question that we also have to analyze in the context of the broader global review of deals that is happening, because we're seeing more and more often this divergence in deals where you have the EC still open for business on remedies, the CMA open for business on horizontal remedies, but not vertical, and the DOJ not open for remedies, and the FTC not open for remedies at all. And I've seen kind of interesting cases in the last few years where, for example, the EC and the CMA accept a remedy, and the US also accepts a remedy, but does it as a fix-it-first off the books. And it's hard for me to understand from a policy perspective why that is preferable to just agreeing a remedy with all the protections that a consent order gives.
I guess this last comment from Jenn. So first, I guess we have some couple of minutes, like I have scheduled to 15 past noon, so we can just come to some final remarks here. I have 2 points brought by the audience, but I just want first to add on what Jenn just said, because from this international perspective, but also thinking of the Brazilian perspective, I would say that it seems, and this is kind of a provocation, of course, John, but it seems somehow that we could picture this new approach, so to say. Somehow people say there is a bias against big companies, so big is not that beautiful. And there is one connection with this concern that relates to Brazil, because of course all jurisdictions, despite their international connections, would scrutinize a merger mostly inside their internal market effects, wherever they were. But of course, when we are talking about oligopolies and big companies, we are talking about a global dimension of the competition as well. And it's conveyed mostly by merger and acquisitions. And Brazil, for one, is we have plenty of multinationals, plenty of mergers related to multinationals acquiring Brazilian companies, and some Brazilian companies targeting international markets to enlarge their operations and somehow to protect them from being bought just out of the market. But a big company for Brazilian standards, and also measured by HHI or things like that, enormous for a Brazilian market, and maybe not so big for international competition. And whereas some US companies not so big, the other way around, not so big for the internal market, the US internal market, but big enough for being a huge international competitor. So how would you treat this bigness issue, taking into account this kind of dimension?
Jenn, do you want to take that first, or?
Yeah, happy to take it first. I mean, I think this is it's a difficult question, and it's a question that other regulators have been grappling with, both in terms of relative bigness within the jurisdiction of the region, and also compared to global bigness, but also how openness and closeness of relative markets and subsidies from foreign governments really can impact competitive dynamics. And for me, the case where this came up most prominently was when I was in Europe working on the Siemens-Alstom merger, where the way that the EC thought about this merger, which they ultimately prohibited, was that so the parties felt that the deal was really necessary to avoid the competitive existential threat from China. And the Chinese competitor was by far the biggest competitor in the world, growing rapidly and kind of expanding out of China very quickly, had a full monopoly on the Chinese market because China had blocked other competitors from being active there. The competitors in Europe had very high market shares in Europe for the moment, but on a global scale had very moderate shares because there was this sort of nature of competition coming from elsewhere. And the way that the EC looked at this was, for purposes of analyzing kind of the parties' market shares and competitive position, they looked at the fact that they viewed Europe as relatively closed. And so they said, the parties have too high of a market share within Europe, we need to prohibit this transaction. But then on the other hand, when they looked at the threat of competition from China, this was completely sort of discounted. And even though they took the view that China was essentially like subsidizing the market, they refused to kind of see that had an impact on the competitive dynamics in Europe, because when China went and bid for projects in Europe, they could do it effectively at a loss because they had the subsidization behind them that made it impossible for the European competitors to play. So this dynamic was really difficult, and there were some really significant inconsistencies between how the EC thought about the internal common market and the global market that I think would have been really interesting topics to discuss on an appeal, which didn't happen. But ultimately, what came out of all of this in Europe was the foreign subsidies regulation, where the German government, the French government said, hang on, we need to actually find a way to account for these global dynamics that do impact competition in Europe, and the subsidization from foreign governments that impacts competitive forces. So it's a very specific situation, especially because it involves these subsidies from foreign governments. But it's a kind of interesting case that has a lot of parallels to this, big in Brazil, small on the global stage. And I think, there's not an easy silver bullet way of looking at those issues. But John, I'm sure you have thoughts on this as well.
I without talking about your specific example, I agree with your general observation. So, however difficult it is to deal with mergers within a single country, these cross-border international mergers are idiosyncratic. They raise, very specific issues. Companies, and I've been involved in some of these, companies struggle with divergent standards, reporting requirements, and criteria by which these are judged in different jurisdictions. The agencies, on the other hand, deal with questions about how to assess foreign competition. Sometimes it can evaporate rather quickly if exchange rates or export controls or financial controls are imposed or relaxed. Those kind of abrupt and unpredictable changes are less common in domestic mergers, within country mergers. So it's difficult to know how to evaluate them. And then there's the state aid question, which, as you point out, oftentimes intrudes as well. So these are extraordinarily difficult, and they converge on the case you described, Bernardo, where there's an asymmetry between the size of a company in some other jurisdiction and the one in Brazil. and individual country authorities, competition agencies have difficult times knowing how to handle a lot of these cases. To go back to what we were talking about earlier, the standards of assessing and the ability to arrive at effective remedies in those cases is handicapped. Individual countries, are hard pressed to mandate divestitures in some other country, in some other jurisdiction. And so there's just a whole range of additional concerns and constraints on these type of cases, much as Jenn described.
Yeah. I think maybe just one last addition to that. I was having a conversation a couple of weeks ago with Olivier Gersant, who heads the European Commission, and thinking about these merger issues, and was asking him about this point on convergence and divergence of outcome across jurisdictions. Because I think 10 years ago, when you talked about international coordination and merger enforcement, the drive was always consistency. It was one outcome that makes sense across jurisdictions. And of course, you might have different competitive dynamics that drive slightly different outcomes, but especially across the US and the EC, the UK was not an issue at that time. You really saw an effort to get to the same outcome. And that dynamic has really shifted. And, some of these issues that John was just describing come into play in these considerations. But what Olivier said is, what we are focused on now is making sure that we are exchanging information so that when we are looking at the same facts and looking at the same theories, we're getting to the same place. But to the extent that we have different local facts and to the extent that we think about theories differently, we want to make sure that we're coming to the conclusion that makes the most sense for Europe. And we don't really care if that's the same as where the CMA and the DOJ and FTC come out. As a practical matter, I think there have been some questions in the Biden administration about whether essentially the FTC and the DOJ are happy to let the CMA especially do the dirty work, and whether this divergence is not so much about having philosophical differences in how these deals look, but rather the DOJ and FTC sort of sitting back and saying, we're not doing so great in court, but the CMA is going to prohibit this, so we're just going to wait a bit and see where it goes. The FTC and DOJ seem happy to bring their own cases and lose too, but these dynamics around international cooperation and convergence and divergence have certainly shifted in recent years, and I think are going to be really interesting to continue to watch how these agencies play with each other, how the BRICS agencies coordinate with each other. It's really forefront because there's almost no deal that crosses my desk these days that is limited to a single jurisdiction.
That's great, Jenn. I take this as kind of last remarks because it's such a challenge to tackle this coordinate. We have seen this kind of discussion lively at ICN somehow, but it's from the Brazilian perspective, it's really challenging to how to face this new trend, so to say, or old trend, as Jenn say, and try to put them in perspective to build up our own path. But let's hear some final remarks also for John, just to add one piece that's mostly important for economists that from the audience. They have just asked about the role of data. I guess we have talked a bit about it, and somehow how to manage modeling such as elasticities and the like when we are facing this kind of tech markets and zero price markets and the like. So I guess the role of information and the role of data from the economist perspective, and to put this, as you say, that we should stick to providing information that would be instructive and conductive of and thorough analysis of each case. Wherever is your theory of art, you have to prove it and to get evidence to make the case.
So if I'm not sure if I understood the question from the audience exactly, but there's two different two different issues concerning data. One is, and this has been an issue certainly in the tech sector, mergers that are motivated by the acquisition of data, rather than combining anything else that two companies do. You know, one party is interested in compiling data from users of some other entity, seemingly having little or nothing to do with the first one, but when integrated, provides insight that otherwise would not be available to an independent third party, and may make it as a result more difficult for anybody else to get in the business. So if data is increasingly thought of as a motivation for merger, then this really means that the agencies and the process really needs to think hard about how to deal with data as the critical asset to be combined. So that poses a whole series of questions, but it is among the things that the FTC and DOJ are thinking about. There's some mention of this in the discussion of the guidelines about platforms and two-sided markets and the rest, in the sort of the guideline that deals with the tech sector. But again, I think it's fair to say that the discussion there is fairly spare, because it's really hard at this point in time to flesh out exactly everything that would need to be done to analyze this. And the guidelines, you know, in some ways are always, these guidelines too, as I said at the outset, look back on the past 10 years and say, what do we want to change that happened in the past 10 years? But they also try to look ahead, but they can't look ahead 10 years and guarantee you that. They may be able to look ahead 1 or 2 years and think about the new issues that will emerge. But I think we can all be pretty sure that within 5 or 8 years, that the new guidelines, let us say, if they come out in pretty much the form we've seen them, will also need revision, because there will be new issues that will arise. So the other part of the data question, maybe this is a wholly different data question, is how do economists use data to increasingly to analyze traditional considerations like diversion ratios and demand elasticities and the like. This, of course, is you know, when in the past, I'm not sure what the right number of years is, but certainly in the past 15 or 20 years, data analysis for merger review, merger investigations has become very high tech, of course, and it requires vast amounts of computing power, econometricians of the first order, people who know exactly how to use the frameworks and models that we presently have, and to put the data into a usable framework. Agencies now devote considerable more time to single major investigations than they used to, because it's become very resource intensive. One of the factors, which I certainly saw at the FTC, is that for any major investigation or case that might be brought, the agency had to think hard about what they would not, as a result, be able to do. The opportunity cost of a major case is not being able to conduct other investigations. They may deserve that, but with agency budgets being fairly tight and with the cost of individual cases, and certainly major cases, exploding rapidly, it does create sort of difficulties in internal resource allocation and management. So those are answers from 30,000 feet. The details are, as they always are, in the devil is definitely in the details, Bernardo.
Yeah, I guess let's just end with another saying. I guess Bruno would add some just final remarks to close the session. But I guess one message I will have in one line would be the proof of the pudding is on the eating. Let's see, as Jenn says, what we will have in place in the US and elsewhere. I guess it has been a pleasure and very helpful. So thank you so much for this. Thanks the audience. Bruno would just close the session because we have run out of time. Thank you so much for your time. Thank you so much.
Pleasure.
Thank you, Bernardo, and thank you, Jenn, for your comments. It's been a great pleasure. Bruno, thank you for hosting this.
Thank you,
Did it from
John.
his-
Yeah, thank you, John. Thank you, Jenn. I think this is the type of debate that we want to foment here at IBRAC. Hearing about the birthplace of antitrust, how you guys been discussing merger guidelines, and at the moment we're discussing ours is quite important for us to take these different views, considering the pendulum in the US, which goes in every side from time to time. I think very good considerations for our reality here. So once again, thanks a lot for your the possibility of you being here. Even this is virtual, we hope next time you're here in person with us. Thanks a lot.
And that's being recorded, so we'll spread it to a very large audience and to warm up for our conference. Thank you.
Yeah, and thanks, Bernardo. Congratulations for organizing this event. Thanks, everyone.
Thank you, guys.
Thank you.
Have a nice day.
It's a pleasure. Bye.
Bye-bye.